But there are legal questions that we're dealing with, which is a great tee up for Steve. So if nobody has any more questions, we'll let Mr. Saxon, Chairman of Groom Law Group, talk to us about where we are on that front.
Thank you. I wanted to start off with one kind of personal note. Thank you to all three of you guys. Your organizations that you represent give us hope, hope that we can have a better retirement system in this country. It's nice to see that we have some adults here in Washington thinking about serious problems we face in the retirement space, and that you're coming up with solutions. It does give us hope. But for me, this project's invigorating. It's so different. My partner, Brigham Winters, is here. We deal with a lot of very tough issues, frustrating issues, the fiduciary rules. One example of that, and this is working on something, building something where you can see the light at the end of the tunnel is going to be really good for average American workers. Our role from the legal standpoint is actually pretty simple, and that is, if you look at the record-keeping system in the United States, since 1978, when we first introduced the 401k plan, record keepers have never been fiduciaries. They work as directed by the plan sponsors. They're administrators, and the law is pretty clear on that. The fiduciary reg will complicate that, if you will. Let's ignore the fiduciary reg for a second. The record keepers that we're working with, and Nevin's question is kind of related to this, the record keepers, they don't want to become fiduciaries in conjunction with rolling out this product, nor do plan sponsors. Plan sponsors are named fiduciaries of the plan. They are fiduciaries, but they don't want to be a fiduciary in conjunction with the very important decision relating to that safe harbor IRA out there and the decision to move that IRA into the new plan. They don't want to be responsible for that. They want to leave that to the participant. So that's what we did, and we've already, at Groom, we've already opined that there is a way to structure this program through the use of a consent process that has an affirmative consent part and a negative consent part, where we give lots of information to the participant, and at the end of the day, the participant makes the decision. They actually make the decision to consent to the roll into the new plan. From a public policy standpoint, and you guys have all touched on this is a no-brainer. It allows for the consolidation of account balances. Spencer's talked about the technology to make that happen. Legally, what we want to have happen is we want to be able to implement that consent process and be able to represent to the parties that we're dealing with, all of the record keepers out there, and through the record keepers, the plan sponsors, that this can be done without creating additional fiduciary liability for them. As I mentioned, we've already opined to that. We've been working with the Labor Department. As you know, the Labor Department hasn't been focusing so much attention the last couple of years on issuing a lot of advisory opinions. I think there have been 2 or 3 significant ones in the last 5 years. This one is in line. We are actively engaged with the department. We would like them to confirm our opinion that this structure will not create fiduciary status for the players, and that it is possible for the participant to make that decision without creating additional liability for those other players. One kind of response related to your point, Evan, is when you talk to the record keepers, and this is a little bit surprising to me, what they were most concerned about is the qualified status of the money coming into the new plan. So the plan sponsor, they want to be assured that this money is clean, this money can be brought into their plan without creating additional problems for that. The Internal Revenue Service is giving us some rulings that have helped us in that regard. we can all now rely on what the 5500 says and looking at that. So that's been one thing. There is some other things that need to happen. The record keeper, they're going to have to amend their agreements with the plan sponsors. And they're going to have to go to the plan sponsors and say something like, we have a new product. We hope this will be viewed positively by you by enhancing your ability to serve the retirement needs of your participants, helping them to obtain retirement security. We want you to agree to allow us to use this technology and allow these participants to come in. The plan sponsor doesn't have to look at each and every case. They just need to kind of at the contract level generically say, this makes a lot of sense to us. Enabling our employees to consolidate all these ERISAs that they have out there in our plan, that's good for them. And also probably good for the employer too, because at the end of the day, their account balances will grow, and then their per participant cost on the administrative cost of the plan will go down. So that's the easy part. Any questions? Yes, sir. So the question is, what exactly does the advisory opinion concern? And does it deal specifically with the less than $5,000 account balances? It does. That's what it does. But I would tell you, from analyzing the legal principles involved, that the structure of the consent process would work, I think. It's not based on the mandatory distribution rules. It's based on the fact that you've given the participants sufficient information on a number of occasions to make an informed, prudent decision about what they should be doing. And at the end of the day, if they don't do anything, then the negative consent process takes over.
Let me add a practical note there, because this is one of the modifications that's been made, as we've worked with Groom and labor, is we thought originally that we just do negative consent across the, yeah, get my mic, thanks, Francis. We do negative consent kind of for everybody. It turns out that there are good ways to gain affirmative consent. So we built what's called a consent waterfall, which is we'll first seek to get affirmative consent from the participant. There's ways to do that electronically or even in a call center. But that leaves a problem. And this is buried in our industry, but you'd all be familiar with it. When we talk about small accounts, there are some really small accounts out there. Something like, 7% of the accounts have less than $200 in them. Those participants are never going to respond. They're not going to call. They're not going to, hit up a website and give authorization. So we stuck with the negative consent at the bottom of the consent waterfall because we need to deal with that problem. Okay, you can't leave $50 accounts sitting in an employer-sponsored plan for 30 years. It's just a bad way to operate a system. So we've modified the advisory opinion request so that we bake in affirmative consent wherever we can get it. Now, back to the point is, we created the electronic highway and the means. Other people will come along and say, wait, can I use the highway because I'll go get consent for my customers who want me to do larger balances for their participants. Great. So that's part of the groundwork that we're trying to lay here.
There's a lot of information about the use of negative consent. Years ago, there was a fairly significant advisory opinion issued in conjunction with the substitution of mutual funds from one fund to another fund under a 401k system, advisory opinion 9716A. And in that, I worked on that one. We ended up negotiating a bunch of terms and conditions on the advance notice and things you need to say to get actual consent. So this opinion request is based on that and others that we've seen. And if you look at the use of negative consent, it's in the QDIA regs, it's in auto enrollment. It's all over the place, and the reason it's there is for the same reason that Spencer was talking about. At the end of the day, there are some folks who are just not going to they're not going to respond. They're not going to get back to you. And then, so from a public policy standpoint, you say, what are we going to do? And this one I thought was fairly easy. You move the money to where the participant now hangs their hat, where they're working in their new plan. Thank you.
So this must have been an incredibly well-planned event because we're about 5 minutes before the hour. If there are any additional questions, first we appreciate the great interaction from the audience. We didn't really give anybody a chance to ask the senator any questions. Not that I'm calling him out or anything. But if not, we're happy to take questions in private afterwards. We're happy to hear your input for additional areas that we should explore, who we should get involved, those types of things. So we appreciate your attendance. There is free lunch. Yes, there is free lunch to you anyway. And thank you, everybody, for coming.